Welcome back to another absolutely wild courtroom breakdown. And folks, buckle up, because today's session is one of the longest, most intense, and most emotionally charged dockets we have ever covered on this channel. We are stepping inside a real Bexar County, Texas courtroom for a session that runs nearly 3 hours. And I promise you, not a single minute is wasted. Let me set the stage. We've got a judge who runs her courtroom like a well-oiled machine. She's sharp, she's funny, she's compassionate when she needs to be, and she is absolutely ruthless when defendants try to play games. Today alone, she's going to handle dozens of cases, and I'm talking everything from routine docket calls to felony plea deals, occupational license hearings, motions to revoke probation, a full-blown speedy trial dispute, and multiple arrest warrants issued live on the spot for people who thought they could just not show up. Spoiler alert, that does not go well for them. Here's what you need to watch for. A man named Rahul Iglesias is about to get the wake-up call of his life when the judge looks him dead in the eye and asks, "Do you want to go to prison?" Because with up to 10 years on the table, his excuses are running thin. A felony DWI defendant named Lorenzo Garcia is fighting to get an occupational driver's license because the Uber rides are bankrupting him. A young mother named Galaxy Guerrero Alvarez is caught between a family violence case and a CPS investigation involving her own father. An 18-year-old kid named Aiden Falcone, who was shot and has a permanently injured arm, is about to accept a plea deal that could change the trajectory of his entire life. And then there's Andrew Shepard, whose case has been floating in the system for over 5 years, and his lawyer is arguing the whole thing should be thrown out on speedy trial grounds. On top of all that, the judge takes time out of her packed schedule to welcome criminal justice interns, crack jokes about a terrible Netflix movie, take photos with the defendant's family, and even quiz defense attorneys about whether they could pass a GED test. This courtroom is alive, it's real, and it's everything you never see on legal dramas on TV. So settle in, hit that like button right now, and let's break down every single moment. Here we go.
When I call the docket, you need to stand and let me know you're here. Otherwise, I'm going to assume you're not here and a warrant may be issued for your arrest. You need to remove the hats. All right. Vasco Brobham. Thank you. State Hiller is being reset for June 1st. Troy Moore. Christopher Vrum. Christopher Adam Veroman. Carlos Arredondo, custody. Lucio Soto. Everyone, you need to stand when your name is called. Buna Taylor. Thank you. Jose Morales. Kristen Clark. Custody. Dwight Sorrell. Derek Carpio. Wes Ruiz. Angel Farias. Angel Steve Farias or Farias. Moses Hernandez. Deputy Laura, anyone who's not here by 9:30, they need to go into custody. Jose Cedillo, custody. Amador Garza. Theodore Garcia, custody. Darnell Dotson. Here. Thank you. Sergio Rodriguez. Sergio Ricardo Rodriguez. Rodolfo Palma. Uvaldo Navarro. Billy Gutierrez.
You're on that. I got a call from you. He says it's in Dallas. That's some kind of
All right. All right, you need to provide documentation before business day closes. Arturo Ontiveros. Ronnie Cerna. Kimberly Tarwater. Angel Farias or Farias. Nathaniel Munoz. Ruby Luis. Mario Manzano. Jose Marino. Aiden Lujan Falcone. Lorenzo Garcia. Brady Lozano, your case has been dismissed. Hopefully he's not still in the Bexar County Jail. Andrew Shepard. Raul Iglesias.
I'm here if needed.
Thank you. Galaxy Guerrero Alvarez.
He's in custody, I'll confer.
Thank you. Maverick Ennis. Maverick Dennis Ennis. Melissa Barton, custody. Amadeon Smith, custody. Eric Cantu, that's 10. Alex Miasek. Good morning. Dennis Johnson.
Got 130.
Morris Thompson. Morris Harvey Thompson.
That's at 1 o'clock. He said he could be on June.
All right, thank you. All right, anyone who came in later, your name was not called. What's your name?
Right off the bat, the judge is laying down the law. Literally. If your name is called and you don't stand up, she's going to assume you're not here, and a warrant could be issued for your arrest. And notice that little detail. Remove the hats. This is a courtroom, not a sports bar. This judge demands respect in her courtroom, and honestly, that's exactly how it should be. Every single person in this room needs to understand. The moment you walk through those doors, you are in the judge's house. Her rules apply. Now watch how fast she moves through this docket. She's got dozens of names to get through, and she is not wasting a single second.
All right, anyone else? All right, everyone, please confer.
Mr. Moreno?
Oh, never mind.
I'm gonna back you up. Yes, you know.
Oh.
And here's going to see the
You
so
have.
I don't like this. Thank you.
I have. Oh.
In process. Yes. No. Touch. Both sides.
Now pay attention to how many names are being called with the word custody next to them. That means those defendants are currently locked up. They're either in the Bexar County Jail or being held somewhere, and they'll be brought before the judge when their case is called. But here's the part that always gets me. The judge just announced that anyone who isn't here by 9:30 needs to go into custody. That's not a suggestion, that's an order. Deputy Laura is taking notes. If you were supposed to be here and you're running late, you better be sprinting through that parking lot right now, because this judge has zero patience for tardiness. And honestly, can you blame her? She's got a courtroom full of people, attorneys waiting, prosecutors ready to go. One person's laziness holds up the entire system.
Yes, I made sure that I brought mine today.
I know the feeling of work.
Yes.
But I'm not in denial.
Hey, so I'm doing that tonight, right?
Not
You're something.
exhausted. Sure. Okay, make the paths.
But I have to just. Just going to get this.
Could it still show up on the CIC what name should like her? Yeah.
Wait, did you catch that? The judge just casually drops that Freddie Lozano's case has been dismissed, and then adds, hopefully he's not still in the Bexar County jail. That right there is a real problem in the criminal justice system. Cases get dismissed for all sorts of reasons. Insufficient evidence, procedural errors.
Her alias says we can tie it to her date of her birthday or something. So that they on the house like.
Now here's a name that's going to come back later in a big way. Galaxy Guerrero Alvarez. She's currently in custody, and as we'll see later in this session, her case involves family violence, CPS involvement, and some seriously complicated family dynamics. Keep that name in the back of your mind, because when her case finally comes up, the judge is going to handle it in a way that shows exactly why she's so respected in this courtroom. But for now, just note, she's in custody, and the deputy is confirming her status. The wheels of justice are already turning.
Here, just it's
Thank you.
there.
Ontiveros?
Good morning. Yeah.
Oh, sorry.
And I'm gonna go ahead and add it. I know I came over to. What's the difference? Oh, we're starting off that cliff. He inspired me from. You don't learn.
Julia.
Probably. I'm just saying the other side. I have not looked at this. But yes, typically, unless.
Yeah, it might be. Yeah.
Hi, how are you?
Everybody report to the clerk that we're ready.
No, not you. Fine. Let me-
Sure, sure. You let me know what you want.
It's not us.
Oh, there's the one. We get report.
Yes, it is. Yeah.
This is the first one. So that's what I got to do. Oh, I'm sorry. I was late.
Okay.
Well, then I'm not even here.
No, please. All the things and then okay.
You gonna do it for you?
Very probably. So.
Hey.
You know what?
Hi. Hi. Oh, thank you so much. You're so awesome.
I was like, there's
Yes, hey. You know what? I was telling everybody, I'm like, I can't remember who I gave the books, who was taking books. So how was your guys' drive back?
It was good. We stopped at a barbecue place. It's so good.
Oh, wow. So I ended up flying back in because I was promising to take my students on a tour of the Bexar County Jail. So I had to do that, but they always look forward to that.
Yeah. The jail.
But I enjoyed the
It
conference.
was good. It
Yeah.
was really good. A lot of information. Looking forward to Nashville.
Yes.
So.
All righty, guys. Have a good one. Thank you so much.
Oh,
Montana, Mario Montana.
It's a bonnie. You don't think.
Thank you. Sorry. She's out for her.
Miss Sawyer? Is your client here? He's right there. He's right there. Mario, stand up, please. Mario, second row on this side. Sir, second row on that side. Second row, the other row.
Standing outside just for some reason.
Judge, whenever you're ready, Judge.
But they don't have as well.
Oh, I just wanted to make sure.
Yes.
Yes, ma'am. Mario Manzano, page 6, 2 down.
Well, it's not.
No, I'm saying, you know how they put people involved.
I don't know what you
My party went to go get some. We're not on the same page. Yeah, bring it back.
All right. Mario Manzani, Manzano.
You don't just.
Hi, your client needs to come forward.
Yes.
Hi.
Hey,
Oh, where is he?
Mario. Why he's not.
You need to come forward. No, it's gonna be one of those days today.
I feel it. I feel it already coming on.
Oh, it is. Yeah, most definitely. But you know what? We're gonna bask in the glow of that day.
Good morning, ma'am.
Good morning. So where are we on discovery?
So we have received discovery. I came in last week and got permission to apply for PTD. The client has provided me with it. I'm submitting it right now. And I think it's going to be resolved through PTD. So I'm just asking for a reset to let that get approved and him to report.
All right, Norm, I need a PTD date. All right, May 11th.
May 11th.
Yes,
Perfect.
once you sign the reset form, you excuse, just have a seat. Your attorney will bring that to you.
I'll be with you in just a
All
second.
right, thank you. And court is at 9 in the courtroom.
I will speak with him about that.
All right, thank you.
Thank you.
Hi. Get out of town. Hey, Jake. Jake from State Farm. Do people tell you that all the time?
They used to a lot, but I think it's like falling off. I think it's way more.
Oh, wait a minute. You gonna be a juror? You gotta be up here then.
No, he used his exception. He was like, I should go to class.
Yeah.
But he got his 3 years, so.
Yeah.
I took a picture.
Yes.
It's only the first one.
Simply. Do you want both of you?
No.
That's okay.
Yeah.
No, I don't.
Well, I tell you what, Deputy Laura is excellent at photos. And is that an Android? Oh, Androids do great work.
Yes.
Okay, awesome.
All right, I love this moment. The judge is just having a genuine human conversation with people in the courtroom. She's talking about a conference she attended, how she flew back to take her students on a tour of the Bexar County jail. Yes, a jail tour for students. And she's laughing and catching up with people. This is something you don't see on TV legal dramas. Real courtrooms have downtime. There are moments between cases where the judge, the attorneys, the staff, they're all just people. They talk about their weekends, they joke around, they build relationships. And this judge clearly has strong relationships with the people who work in her courtroom. That matters because when things get tense, and they will, that foundation of mutual respect keeps everything running smoothly.
Deputy Laura, can you take a photo of him with his dad?
He wants it, bro.
Just press the button like you.
And they passed it.
Let me take a look at you. I mean, I love Novik, but. Alright. I send it to Dad.
That's so cute.
Okay, ready?
You want me in there?
I just give you a photo. Hi, Sanjay.
All right, nice to meet you, sir. You're a juror today?
Hey, how's it going?
Huh?
Oh, great. I can't complain.
That's what we.
Oh, the weather is great.
Good weather for walk, even after.
Yes. So I'm gonna be on it.
We just want the dummy.
But then.
I guess I'm here. I guess I'm here.
During the lunch hour.
Mhm.
Getting home, it's too much.
Oh, no, I hear
It's kind of
you.
a weird thing. It's.
I'd rather just take care of it and that's be done with it.
Yeah,
You're on probation.
it's always good seeing you.
No MTR or anything like that.
I've been in and out, what's going on, and I go back to my company. Okay.
Okay.
I represented them 2 years ago. I did those.
Yes, sir.
Okay.
The spam calls continue.
Judge, we're ready if you are.
All right, just give me a moment.
Yes, ma'am.
You may have interest.
It's so hard.
I know. Because it seems like a great, right? But it was I was the sheriff. Yeah. In a heartbeat. When I first started in 1980.
Alright, now we're getting into the actual cases. Mario Manzano's attorney is explaining that they've received discovery. That's all the evidence and information from the prosecution. And they've applied for PTD, which stands for pretrial diversion. This is a huge deal. Pretrial diversion is essentially a program that allows defendants to avoid a criminal conviction entirely if they complete certain requirements. It's typically offered for lower-level offenses or first-time offenders. The attorney is confident the case will be resolved through PTD, which means if Mario completes the program, this charge could disappear from his record entirely. That's life-changing. The judge is resetting the case to May 11th to let the process play out. Smart, efficient, and fair. That's how you run a courtroom.
And they would sleep on the truck, and I'm thinking, what can I do here to do? And then about was on in Dallas. And there was no and that's when we started saying that hey, don't live behind
Two cases?
My back is
All right, who's next?
Okay, I need to talk about this because it's genuinely hilarious. The judge just looked at someone and said, "Jake? Jake from State Farm? Do people tell you that all the time?" And the guy's reaction is priceless. This is what makes this courtroom so special. Yes, it's serious. Yes, people's lives are at stake. But the judge understands that a little bit of humor goes a long way in making an incredibly stressful environment just a little more bearable. And then she asks Deputy Laura to take a photo of the guy with his dad. In a courtroom. Think about that. Most people associate courtrooms with the worst days of their lives, and this judge is creating a moment of connection and warmth. She even comments, "That's so cute." I'm sorry, but this judge is a national treasure, and I will hear no arguments otherwise.
Who is next?
Yes, ma'am. Next is Iglesias Raul, and he's on page 730. Yes,
Raul Iglesias. Hey,
I'm here because,
oh, you're on this side. We'll figure out what's going on.
okay.
Hello. How are you doing today?
Fine. I got these two things. I don't know if that helps you, Judge, from the probation office. I gave it.
We good.
All right, so on this one, does he owe any restitution?
Judge,
Because
the
it says,
restitution is to be determined on both of those. I will get with the office to see if letters have been sent out and so forth. The issues that we're having with Mr. Iglesias, on one of his cases, he was placed on probation for deferred adjudication for 2 years. That 2 years is going to be up in July of this year. There are still some outstanding things that he needs to complete, defensive driving, GED, and then he just hasn't been in overall compliance with his UAs.
All right.
We have not had a UA since July of last year. And
you're doing a UA today. What's the result going to be? All right, why are you not doing your UAs? Do you want to go to prison?
No, ma'am.
The range of punishment on these cases, on the case ended in 8-9, the range of punishment is up to 10 years in the prison. Do you want to go to prison? The other range of punishment on the case ended in 0-0 is up to 2 years in the state jail facility. If you get sentenced to 2 years in the state jail facility, that's day for day. Do you understand? Do you want to go to prison? Then you had better find time. And this whole thing about you're just not doing it, why are you not doing it?
confidence position.
All right, so let me just tell you, this is the last conversation we're gonna have about this. The next conversation we have, if we have one in regards to you're not reporting for your UAs, you're not making payments towards your financial obligations. What's gonna end up happening, I'm gonna see this, there's not gonna be a compliance hearing. They're gonna ask me what should be done. You see where that other is checked? I'm gonna put file MTR. And then what will end up happening if a motion to revoke is filed, you'll end up being taken into custody. Police will arrest you wherever you may be. If you're about to have dinner, they'll arrest you right there. If you're in line to pick up your children, they'll arrest you in line if they find you there. And then you will be taken to the Bexar County Jail. You either make bond or not make bond. You'll either hire an attorney or one will be appointed for you, and we will hear the motion to revoke. And then if the allegations in the motion to revoke are found true, you're looking at potentially 10 years in one case and 2 in the other. Do you understand? You are not to miss another UA testing. Do you understand? And you're going to provide a UA today.
Yes, ma'am.
Yes.
Anything
idea.
else?
Judge, the CSO is asking for his conditions to be amended to include the IVR hotline for 60 days, complete the aggressive driving course, and enroll in his GED courses within 30 days.
All right. Are you currently employed?
No, ma'am. Self-employed.
Huh?
I'm self-employed.
Doing what?
Mechanical.
So I don't even understand why you can't make these appointments. Because if you're self-employed, you make your own hours.
On the driving one, I'm doing that.
I'm
I'm
sorry, what?
already enrolled in the driving course.
The defensive driving?
Yes, ma'am.
All right, then you need to provide them proof of that because they don't have proof of that. And if you don't provide them proof, you might as well not have done it. All right,
And
you understand?
complete it, and complete it.
Yes, sir.
And what is the issue with the GED?
I'm still looking into one of the schools, see if I could get enrolled.
All right, so here's the thing. With the GED, I'm going to give him a choice. He can either do the GED or go to a trade school, do something to improve his lot in life. Because I realize that sometimes the GED is more difficult for
Is it?
people.
Okay.
Well, I mean, sometimes it's difficult because I think they want you to do math. You know what I think I should do, Vashon? Before I leave, I should make defense attorneys take the GED test and see if any of them will pass. All right. So you're going to alternate main conditions. It's going to be the IVR hotline or either you can do the patch.
All right, now things are about to get serious. We're moving into the Raul Iglesias compliance hearing, and this is one of the most important moments in the entire session. The probation officer has handed the judge paperwork, and they're about to go through exactly what Iglesias has and hasn't done while on probation. For those who don't know, a compliance hearing is when the court checks in on a defendant who is on probation or deferred adjudication to see if they're meeting all their conditions. If they're not, the consequences can be severe, up to and including revocation, which means the original prison sentence gets imposed. Iglesias is about to find out just how thin the ice he's skating on really is.
And you're going to provide them proof of your enrollment in the defensive driving course. Do you understand?
Yes, ma'am.
And you're going to take a UA today. All right.
The IVR hotline, how often do you want him tested?
Once a week.
60 days.
Let's do 30 and see how he does. I don't want to interfere with other things he has to complete.
The important thing is you have to finish this because your probation's running out and this judge will revoke you.
Let me break down what the probation officer just laid out, because it's not good for Iglesias. He was placed on deferred adjudication for 2 years. That 2-year clock is almost up. It expires in July. And here's the problem. He still hasn't completed defensive driving. He hasn't gotten his GED. He hasn't been in overall compliance with his urinalysis testing. In fact, he hasn't submitted a single drug test since July of last year. That's almost a full year without a UA on probation. For a case where one charge carries up to 10 years in prison, folks, this is not how you handle a second chance. The judge is about to make that crystal clear.
You understand?
Yes, sir.
All right. Thank you, Mr. Seeloff.
Thank you. I'll talk to the coordinator. That's why I was going to ask her, what do you call it?
I'll just put it down as a motion to revoke hearing.
Here it comes, the moment that defines this entire hearing. The judge asks him flat out, "Why are you not doing your UAs? Do you want to go to prison?" And she doesn't stop there. She lays out the exact range of punishment, up to 10 years in prison on one case, up to 2 years in a state jail facility on the other, and state jail time is served day for day, meaning there's no early release, no good behavior credits. Every single day of that sentence gets served. When the judge asks, "Do you want to go to prison?" she's not being rhetorical. She's giving him one last chance to hear the reality of his situation before it's too late. This is a judge who genuinely does not want to send this man to prison, but she will if he forces her hand. Now the judge is spelling out exactly what happens next if he doesn't comply. And I want everyone to understand this because it's important. She says the next time this comes up, she's going to check the box that says file MTR. That's a motion to revoke. Once that's filed, the police will come find you. She literally says, if you're about to have dinner, they'll arrest you right there. If you're in line to pick up your children, they'll arrest you in line. That is not a threat. That is a promise. And it is a factual description of how the process works. Once an MTR is filed, and a warrant is issued, law enforcement actively goes looking for you. And then you're sitting in the Bexar County jail trying to figure out how you let it get to this point. She's painting the picture as vividly as possible because she wants this to be the wake-up call that sticks.
Anyone else ready?
Yes, ma'am. Lorenzo Garcia, page 7, 1 down.
Hey, how's it going?
How are you this morning?
Doing okay. I cannot complain.
You have my favorite court reporter today. We go way back.
Oh, hey.
How you doing today?
You know, in the words of Principal Ava from elementary, do y'all go back to molars?
No, not quite that far.
All righty. So what are we here for with Mr. Lorenzo?
Mr. Garcia has an occupational driver's license application that's pending in front of the court today.
All right. Can you have them pull that? Because they didn't.
And here's where the judge catches him in a contradiction that I think a lot of people in the comments are gonna have opinions about. She asks if he's employed, and he says he's self-employed as a mechanic. And the judge immediately fires back. I don't even understand why you can't make these appointments, because if you're self-employed, you make your own hours. That is such a great point. One of the most common excuses defendants give for missing probation appointments is work conflicts. But if you're your own boss, that excuse evaporates. To his credit, he says he's already enrolled in the defensive driving course, but the judge makes another excellent point. If you don't provide proof to your probation officer, you might as well not have done it. Documentation is everything in the criminal justice system. Would you have been this patient with someone who keeps making excuses? Let me know in the comments.
The application, I've got the application and a copy of the order if you need. Just,
Have you conferred with the state?
I have. I conferred with Mr. Prater yesterday on this case. And the state is silent. They don't have a position one way or another. This is a felony DWI, so there was a waiting period that we had to go through. He was placed on probation, what, over a year ago, right now? A year this month. And so he's gone through the waiting period.
Now this This is the moment that separates a good judge from a great one. Instead of just demanding that Iglesias get his GED and leaving it at that, she offers him a choice, GED or trade school. And her reasoning is so thoughtful. She acknowledges that sometimes the GED is more difficult for people. She's not looking down on him for that. She's recognizing a reality and finding a solution. The goal isn't to punish him with an impossible requirement, it's to improve his life. A trade school certificate can open doors just as effectively as a GED in many fields, especially for someone who's already working as a mechanic. And then she gets the whole courtroom laughing by suggesting she should make the defense attorneys take the GED test before she leaves to see if any of them would pass. That is comedy gold, and it also makes an important point. The GED is hard. Let's not pretend otherwise.
And so we wanted to do an application. Uber fees are killing him.
Okay.
And so he is anxious to be able to at least go to work and drive to work. He still has ignition interlock. We got contacted by Barbara last week, and she asked us to provide her the proof of the ignition interlock with the latest calibration for this month, which
Okay.
we did.
Okay.
And so he's in full compliance, Judge. We just are trying to get him an occupational license so he can.
Okay, so it's required that we have hearings on these. So we're gonna go on the record with this hearing. And it appears from my review of the application, everything appears to be in order. The main thing is having the ignition interlock and having insurance. So if for some reason, if your insurance.
For those wondering what the IVR hotline is, it stands for Interactive Voice Response. It's essentially a phone-based check-in system where the defendant calls in regularly and the system can randomly select them for drug testing. It's a way to monitor compliance without requiring them to physically go to the probation office every time. The judge is setting it for 30 days to start, which is relatively lenient. She says she doesn't want to interfere with the other things he has to complete. That's strategic thinking. She knows that if she piles on too many requirements at once, he's more likely to fail. But the defense attorney drives the point home. The important thing is you have to finish this because your probation's running out and this judge will revoke you. That's his own lawyer telling him. Take this seriously or you're going to prison. When your defense attorney is warning you, you know it's real.
Insurance ends up lapsing, then you know you're not allowed to drive. All right, we're gonna go on the record. The court is calling 2026 CI 05308 N. Ray Lorenzo Garcia for the defense
David McLean for the defense.
and for the state. All right, this is a request for, I should say, an application for an occupational license. The court is required to have a hearing. Defense, you may proceed.
Thank you, Your Honor. Your Honor, this morning we have the application for an occupational license. This is for a felony DWI. My client has completed the requisite time before applying for this license. And so the application is timely now. He has provided attached to the application proof of insurance, his certified driving record, which show that he has not had any other violations or anything since being placed on probation. He currently has ignition interlock in his car. We provided proof of that to the staff attorney last week that has a current calibration and a current fees paid. He is willing to comply with all the requirements this court would impose on him. He just is requesting that he has an application for this occupational license so he can go to work, attend probation, attend court if necessary, go to church and take care of his basic needs.
All right, state.
State of Bexar.
Oh, if you can come forward though, please.
I call.
That's okay. All right, if you could sign here, this, you're silent, but this is just approving the form in which it's in. But. All right, so I'm going to grant your application and sign the order. Make sure that you have a copy of this with you at all times. You understand? And read over it because you're only allowed to drive during the times that's presented in the application and in the order, okay?
Yes, ma'am.
Do you have any questions about anything? Thank you.
Of course.
Okay.
We're going to get certified copies of this right now. Okay. Judge, thank you so much.
All right, you're welcome. Thank you.
The excuse.
Yes, you're.
Thank you, Your Honor.
Oh, and defense,
Yes, Judge.
if he wants to check in with probation and make sure everything is okay, if there's any concerns
Sure.
they have, but I know they don't, but just since
All right, we're transitioning to a very different kind of case now. Lorenzo Garcia is up, and his attorney, Dave McClan, is here for an occupational driver's license application. Now, what's beautiful about this moment is the courtroom banter. The judge says the court reporter is her favorite reporter today and that they go way back. Then she references the TV show Abbott Elementary, specifically the character Principal Ava, and asks if they go back to MERS. That's a deep cut reference, and the fact that this judge is quoting sitcoms in between felony cases tells you everything you need to know about her personality. She keeps the courtroom human while maintaining absolute professionalism when it matters. Now let's see how this occupational license hearing plays out.
he's already here.
Since he's here.
Yes, all right, thank you.
I'm gonna be back.
All right, anyone else ready?
Yes, ma'am. Jose Moreno, page 6, 3 down.
Jose Moreno?
Let me explain what's happening legally here because it's important context. Lorenzo Garcia was convicted of a felony DWI. In Texas, a DWI becomes a felony when it's your third offense or when there are aggravating factors. With a felony DWI, you don't just lose your license. There's a mandatory waiting period before you can even apply for an occupational license. Garcia has now served that waiting period. He's been on probation for about a year. His attorney mentions that Uber fees are killing him, and honestly, I believe it. If you live in a city like San Antonio where public transportation isn't as robust as New York or Chicago, losing your license can effectively cut you off from your livelihood. The state is silent on this application, meaning they're not objecting, but they're also not actively supporting it. Let's see if the judge grants it.
Good morning.
Yes, ma'am.
All right, it has, is Kelly no longer his attorney?
Judge, we didn't file notice when he was initially hired. He's got a DWI pending. I filed notice on the DWI for some reason. We didn't realize we hadn't filed notice on this. So I'm getting that corrected right now.
All right, thank you. All right, so have you conferred with the state?
I've conferred, Judge. We have an offer. It's contingent upon taking care of the DWI and misdemeanor court. I don't have all my discovery on that case yet.
All right, so do you have a setting on the misdemeanor
I
case?
do.
When?
April 15th, Judge.
All right, Norma, if you'll set this at the end of April,
Yes, ma'am. 30th.
all right, once you sign the reset form, you're excused.
Thank you, Judge.
Thank you. Make sure you're on time.
But I don't want that set for this position, Judge, or?
Yes.
Good morning, Judge.
Good morning, how's it going?
Good, how are you?
Oh, great.
Good. Morning.
All right, anyone else?
Yes, ma'am.
Bravo. Thank you.
Vas-
Now the judge goes on the record, and this becomes a formal hearing. The defense attorney lays out the case methodically. Garcia has completed the required waiting period. He has proof of insurance. His certified driving record shows no violations since being placed on probation. He has a functioning ignition interlock device with current calibration and fees paid, and he's willing to comply with whatever restrictions the court imposes. This is textbook. This is exactly how you present an occupational license application. Everything is documented, everything is organized, and the attorney has already cleared it with the state and the judge's staff attorney. If you're a law student or someone thinking about becoming an attorney, take notes on how Dave McClan handled this. Preparation wins cases every single time.
Go Brabham.
Yes, sir. Each one is one.
All right, do you all have all discovery?
The answer to the state, not everything on.
What's missing?
We are missing some medical records.
We have conferred on that.
All right, and so where are the medical records?
They will be submitted today.
and again, I'm going to say this again. I don't understand why people are indicting cases and there's medical records that are needed and people don't have medical records. What if the medical records show nothing? And then somebody's been indicted, they've had to make bond. So when are y'all going to have the medical records?
I would say 30 days, just to make sure that we and that's time to present.
All right, Ms. Ferguson. Set this for 45 days for a plea deadline date. You all need to confer off docket.
We will try.
May 14th.
All right, May 14th. Once you sign the reset form, you're excused.
Thanks, Judge.
Thank you.
I'm a big fan of it.
Huh?
I'm a big fan.
Aw. Thank you. Have a great day.
Which is straight. I would think they'll be for it.
All right, who's next?
No one else is ready, Judge, at this time.
Okay.
And there it is. The judge grants the application and signs the order. But here's the crucial part that Garcia absolutely cannot forget. He must carry a copy of this order with him at all times while driving, and he can only drive during the specific hours listed in the application and the order. If he's caught driving outside those hours, that occupational license is gone, and he could face additional charges. The judge also makes a smart suggestion. She tells his attorney to have Garcia check in with probation while he's already at the courthouse, just to make sure there are no concerns. That's proactive judging. She's not just processing paperwork. She's thinking ahead about what could go wrong and trying to prevent it. This is a win for Garcia, but it comes with serious responsibility.
It's all right. Or it's just think. Simple stuff. You haven't.
Mr. Vega.
I'm gonna go find out. No.
Yes, he's here.
Yeah.
Bill.
Yes, yes, yes. Yes, I remember from last time.
Quick case here, but it highlights something that happens more often than you'd think in the legal world: administrative errors. Jose Moreno's attorney explains that when the client was initially hired, they failed to file a notice of representation on this particular case, even though they filed it on his DWI case in another court. It's a clerical oversight, but in the legal system, paperwork is everything. If the court doesn't have official notice that an attorney represents a defendant, it can cause all kinds of delays and confusion. The attorney is getting it corrected now, and the case has an offer that's contingent on resolving the DWI in misdemeanor court first. They're reset to April 30th, but the judge's final words to the defendant: make sure you're on time. She doesn't let anyone slide.
He is a big. So I was thinking, how much that can be?
Hello. Yes.
Good morning.
Good morning.
I have a big $125,000 case in here on Christopher Adam Broman. I hope I'm saying that right. V as in Victor.
Yes.
How much time would you give me to work on this case if it's a high dollar?
No, I mean, where is he?
I'm gonna step outside and start making phone calls
Okay.
as soon as possible.
Then after that, then if you want to file an affidavit to surrender surety, but it needs to be done today.
Yes, I will.
Okay.
I'm gonna start working right now.
All right, thank you. You have his attorney's information?
Yes, ma'am.
Okay.
It's Austin Haiti.
Yes.
Okay, thanks. Okay, thank you.
Mario Alberto Machado. Morris Harvey Thompson. Andrew Shepherd. Christopher Adam. Peter.
Now, this is a moment I want you all to really pay attention to, because the judge is about to call out a systemic problem in the criminal justice system that doesn't get talked about enough. She's questioning why cases are being indicted, meaning formally charged by a grand jury, when the prosecution doesn't even have all the evidence yet, specifically medical records. Think about what that means. Someone gets arrested, has to post bond, hires a lawyer or gets one appointed, shows up to court multiple times, their life is disrupted, and the state might not even have the medical records that could determine whether the case has any merit at all. What if those records show nothing? That person has been put through the ringer for no reason. This judge isn't afraid to hold the system accountable, not just the defendants. And honestly, we need more judges willing to ask these hard questions. The attorneys seem a bit uncomfortable, but the judge doesn't care. She wants answers.
Darnell Docket. Moisés Fernández. Amador Torres Garza.
Anyone else ready?
Kimberly Ray Arbiter. Pat.
May I approach?
Yes.
I just got off the phone, Mr. Hagee. He said his client was given permission to appear by Zoom,
Mhm.
and he is on GPS because he lives in Abilene, Texas.
Okay, well, we'll see if he zooms in.
Okay.
All right, thank you.
Reagan. You have your sign, your sign.
All right, here's a case that jumps out immediately because of the numbers. A $125,000 bond. That is a significant bond, which tells us this is a serious charge. The attorney is just being appointed and needs to make phone calls right away. The judge is firm. If you want to file an affidavit to surrender the surety, meaning the bail bond company wants to pull their bond, it needs to be done today. That's the judge setting a hard deadline. When you're dealing with a case this serious and a bond that high, there's no room for delays or excuses. The attorney, Austin Haley, says he's going to start working immediately. That's the urgency you want to see from a defense attorney when someone's freedom is on the line.
Yes, we are aware and Judge Ortiz has a different day.
Yeah, but they
Morning.
can first. Okay.
Thank you.
Thank you.
Here's an interesting development. An attorney calls in to say his client was given permission to appear by Zoom because he lives in Abilene, Texas, and he's on GPS monitoring. For those who don't know, Abilene is about 4 hours from San Antonio. Requiring someone on GPS monitoring to drive 8 hours round trip for a court appearance that might take 10 minutes is impractical, which is why Zoom appearances have become so common in the post-COVID legal world. But as we'll see throughout this session, technology doesn't always cooperate. Unstable internet, frozen screens, audio issues, these are real problems that can disrupt court proceedings. The judge is patient about it, but you can tell she has mixed feelings about virtual appearances. Sometimes you just need people in the room.
All right. Okay.
They just said they didn't have it, so maybe it's just your-
Anyone else ready?
I do not have anybody signing in it, no more judge.
Okay.
But it's here on that. Okay.
Actually, yeah. That's all I need.
There's a few people that have. Right, so she's got. Okay. How do you, so I'll let you out there, get them, you can't. Oh, okay, so he's still not, okay, great, I'll go down. Okay, great. No, I need to.
All right, anyone else ready?
No, ma'am.
Okay. All right, I will be right back.
Yes, ma'am.
There's something that it's because it's perfect. It's like this.
Oh, wait, they're not going. Yeah, she's in jail.
All right. All right, thanks. Oh, thank you. Everyone, please be seated. Bashan, last night I watched a movie and I can never get that time back. No, it's sort of like, when it's my time to leave this world, I'm gonna be thinking about that hour and 30 minutes. Well, let me start by saying this. Maybe if I were 4, I would have enjoyed it. But I try to support everybody. It was with Kelly Rowland.
The cartoon?
No, it's called The Curse of Bridge Hollow.
What?
But you know why I watched it? Because the girl from Stranger Things was in there. You remember that? I can't think of her name now, from the character on Stranger Things where she's the sister. What is her name? I never watched Stranger Things. I just like Erica. And they have little clips about Erica.
Oh.
And they were trying to get her to do to go in this tunnel. And he was giving her this speech about America. And she told him, you can't spell America without Erica. He's like, yeah, that's true. But so I watched it, and the special effects were non-existent. Okay, I have to revisit. I mean, it was sort of cute.
What?
I think it was on Netflix, but it was with Marlon Wayans. And so he and Kelly Rowland, they're married. They're moving to this town that takes Halloween very seriously. And the way they ended it, they're trying to make sort of like a sequel, because they say, oh, you should wait to see how we do Christmas.
Yeah.
So anyone else ready?
Yeah, man.
All right, if your attorney's not here, you need to call them, because we're taking a break at noon and you have to come back in the afternoon. I'm sorry. All right, who are the interns on the first row? Hi. Where's the intern? They're shy. Hi, come on up. Hi, you guys can't be shy in this world. Not in the legal world. Hi, welcome intern. So what's your name?
Esmeralda.
Sarah. Oh, so what are you guys studying?
Criminal justice and criminology.
Okay.
I'm a criminal justice major too. Political science.
And which school?
UTSA. You can hear this real good.
Well, so are you guys thinking of becoming attorneys, or are you just trying to see what's going on? Okay, well, we're gonna get you out here. You got to mix it up to find out what everybody's doing. So attorneys, we have 3 people who are thinking of going into this field. And I'm telling them all, we're multi-millionaires. We're just doing this now just to be doing something. But also, there's a shortage of court reporters.
Judge Science Court reporter is her court.
Yes. And I always tell everybody, I have 3 degrees and the court reporter makes more money than I do. It's a great profession, but it's a lot of hard work. So, James Seeloff,
Yes, ma'am.
introduce yourself to the interns.
Hello,
Tell them
intern
what you do.
James Seeloff.
Esmeralda.
As little as possible. I'm a defense attorney for last 100 years. Nice to see you. Where you go, St. Mary's?
All right, we need to talk about this because it's genuinely one of the most entertaining moments of the entire session. The judge, in between felony cases, warrants, and plea deals, is giving a full movie review of The Curse of Bridge Hollow, starring Marlon Wayans and Kelly Rowland, and her review is brutal. She says the special effects were non-existent, that maybe she would have enjoyed it if she were 4 years old, and that when it's her time to leave this world, she's going to be thinking about that hour and 30 minutes she'll never get back. That is a scorched earth movie review delivered from the bench of a criminal courtroom. She watched it because the actress who plays Erica from Stranger Things was in it, and then she quotes Erica's famous line, "You can't spell America without Erica." I'm sorry, but this judge is absolutely iconic. This is the kind of content that reminds us that judges are human beings with personalities, opinions, and apparently very strong feelings about Netflix movies.
So they're in undergrad right now.
Very interested. Good.
Downtown, yeah, well, my degree is at the downtown campus, downtown, she's at the main campus.
Good luck.
Thank you. And we have to do an internship in order to graduate as well, so.
Oh, well, if you guys want to do an internship here, come on down. Or if you are interested in doing something on the civil side, let me know and I'll talk to judges on the civil side. And we probably will have a jury trial, at least jury selection this afternoon. That's when we do our jury selections and go from there. But at this table are prosecutors. Prosecutors, please raise your hand. Yeah, and so meet them, ask them what they do. Yeah, so guys, they're shy. So just grab a hold of them and bring them out of their shyness. Yeah, so there's no need to be shy here. So please speak with the prosecutors. Yeah, and find out what they do.
Yeah.
Oh, you're welcome. And if you guys have any questions about anything, ask anyone you see here.
Thank you.
All right, welcome.
I do not have docket sheet for it, like the one you used to write out. Do you want that or do you just want to type your notes?
No, that's fine. Just type it in.
Yes, ma'am. He handed me this as well too, because I think the condition maybe she folded it out. We said he was ready.
Okay. All right, Galaxy Guerrero.
Ready, Your Honor.
Okay.
I don't know if you need this. They're gonna withdraw their motion to revoke, but.
Okay.
Let's release. I'll be right with you, okay?
I'm sorry, what?
I wasn't told that we were withdrawing.
All right,
Prosecutor said they were gonna withdraw, but then.
Oh.
The conditions.
Okay, well, where are the family law?
She ran to the bathroom.
All right, we'll wait till they come back.
But good morning, Judge.
Yeah, good morning. So as soon as they come back, we'll take care of this.
I'll be right back.
I'll wait here, huh?
Of course.
This is one of my favorite moments in the entire session. The judge notices criminal justice interns in the courtroom and immediately calls them up to introduce themselves. They're shy, and the judge's response is perfect. You guys can't be shy in this world, not in the legal world. She's already mentoring them, and they've been in the courtroom for about 5 minutes. She introduces them to defense attorneys, tells the prosecutors to raise their hands, and encourages the interns to ask everyone questions. She even offers to connect them with judges on the civil side if they're interested. And here's the kicker. She jokes that all the attorneys are multi-millionaires who are just doing this for fun, and then immediately pivots to a serious plug for court reporting as a career, saying her court reporter makes more money than she does despite her 3 degrees. This judge is investing in the next generation, and that is beautiful to see.
Charles.
Yes, Judge.
I do not have any videos. Okay. All right, the person who is online, you need to appear and unmute.
I want to highlight something the judge said here because it's actually really important career advice that most people don't know about. She says there's a shortage of court reporters, and she's absolutely right. Court reporting is one of the most in-demand and overlooked professions in the legal field. A skilled court reporter can earn 6 figures, especially if they do freelance deposition work in addition to court proceedings. The judge says her court reporter makes more money than she does, and while that might be a bit of an exaggeration, or maybe not, the point stands. If you're watching this and you're thinking about a career in the legal field, but law school isn't in the cards, court reporting is an incredible option. It takes specialized training and it's demanding work, but the earning potential is very real. Shout out to this judge for putting that information out there.
And you need to show your video.
There we go.
What's your name, sir?
Christopher
I'm sorry, Christopher Vroman.
Vroman, V as in Victor.
All right. Just give us a moment. We're awaiting your attorney.
Okay.
All right, thank you.
Thank you.
I'll put you back in the waiting room. See, Mr. Seeloff, best laid plans.
Hurry up and wait.
Oh, yeah.
Doesn't change, does it, Judge?
No, it does not.
Even if
And you
you're
know-
a judge, it's still hurry up
And
and
you
wait.
know what? It never fails that when I was a defense attorney, you would map out where you're gonna go first. You're like, I'm gonna go here first, and then I can work my way down. And then something would happen, either your client wouldn't show up on time, or the judge would be late, and you're just,
I got an email from jail court coordinator last night at 8:45.
Mhm.
Can you please be attorney for the day, but you have to be in person now. And I said, well, wait a minute, I gotta be in Judge Boyd's court. I should be done by 11. I only have one case.
well, two. The
Well,
other two you didn't know about.
Whatever
but-
that was.
But this should be solved. We're
This-
just
they're both
awaiting them.
solved. We're just waiting for the prosecutor. Maybe she ran away. She got scared. Huh? She found out who her defense attorney was and she ran away scared? No? That's the story I'm gonna tell.
All right, Angel Farias.
Remember Galaxy Guerrero Alvarez from earlier? Her name was called during the docket with a note that she's in custody. Now we're finding out what's happening with her case, and it's getting complicated fast. The state is apparently going to withdraw their motion to revoke. That's a big deal, because it means they're not seeking to send her to prison for the probation violations. Instead, they're going to amend her conditions. But wait, there's a wrinkle. The defense attorney was told the state was withdrawing, but the prosecutor who's actually handling the case says she wasn't told about the withdrawal. You see this confusion happen in courtrooms all the time when multiple prosecutors are handling different aspects of a case. The judge is waiting for everyone to get on the same page, and there's a family violence component involving the defendant's father, plus CPS involvement with her children. This case has layers.
Moses Hernandez. Sergio Rodriguez. Rudolph Palma. Billy Gutierrez.
That's my client, Judge. That's the one that's in Dallas that I'm gonna try and get medical records on.
Okay. Nathaniel Munoz.
Did you see him, Judge?
Yes.
Oh.
Ruby Luis. Andrew Shepherd. Maverick Ennis. All right, then we have Galaxy.
Come on up forward. Bailiff.
What's the court summary?
The DA has it. I gave it to you, didn't I?
All right, on this motion to revoke, what's happening with the allegations within the motion?
They're gonna withdraw and amend and alter the conditions, Judge.
That's correct, Your Honor. We're gonna withdraw the allegations or the violations and then the case is gonna be resolved.
And the new case will be dismissed, right?
Yeah, it'll be resolved.
All right, is that misdemeanor?
Yes. Your Honor.
Yes, and County Court 7 impact.
And what are you all asking for with conditions?
Your Honor, we are asking for the defendant to complete it. We are also asking for the defendant to complete the family violence live panel. We're asking her to do the UA hotline for 60 days and submit to UA testing bi-weekly.
And here we see one of the ongoing challenges of modern courtrooms: technology. Christopher Veron has been waiting on Zoom to have his case called, and when they finally bring him in, there are connection issues. The judge asks him to unmute and show his video, and there's that awkward pause where everyone's waiting for the technology to cooperate. This has been a constant theme throughout the pandemic era and beyond. Courts adopted Zoom and virtual appearances out of necessity, and while it's made court more accessible for people who live far away or have transportation issues, it's also introduced a whole new set of problems. Frozen screens, audio cutting out, court reporters who can't hear testimony. These are real obstacles to justice, and this session is going to show us several examples of how they play out in real time.
All right, why is there a request for UA hotline in all of this? Is there an allegation?
The second allegation is for slip up of usage of marijuana in December of last year.
And that's the only thing, marijuana use?
Your Honor, additionally, in the new case, there was an allegation of alcohol intoxication.
Oh, okay.
Probation?
Yes, Judge.
On this case, is there an updated tab?
No, Judge, the last applicant 2024, she completed intensive outpatient treatment as well as her parenting class.
The judge and the defense attorney just summed up the entire legal profession in 3 words: hurry up and wait. That is the absolute truth of what it's like to practice law, especially in criminal court. You rush to get to court on time, you prepare your cases, you organize your schedule to hit multiple courtrooms in one morning, and then you sit and wait for your case to be called, for the other side to be ready, for the judge to finish another hearing, for a client who may or may not show up. The judge even reminisces about when she was a defense attorney and how she would map out her entire morning only to have everything derailed by a late client or a late judge. Any attorney watching this is nodding their head right now. This is the reality of the job that nobody tells you about in law school.
There's only been one positive UA.
All right. And then is there going to be any no contact orders?
It's a father.
Maybe a no or injurious contact order. It's the alleged complainant is the defendant's father.
All right, so what's going on in your life? What do you need to be successful on this probation?
Just complete my UAs and just follow the
Or is that by condition?
Well, I mean, do you have anger issues?
The judge is now going back through the docket, calling names of defendants who still haven't been reached. Angel Fios, Moses Hernandez, Sergio Rodriguez, Rudolph Palma, Billy Gutierrez, Nathaniel Munoz, Ruby Louise, Andrew Shepard, Maverick Innes. That is a lot of people who either haven't shown up or whose cases haven't been addressed yet. And remember what the judge said at the beginning. If you're not here by 9:30, there are consequences. It's now well past that mark, and the patience is wearing thin. Some of these defendants have attorneys who are working other courtrooms, some are supposed to be on Zoom, and some have simply vanished. The clock is ticking for all of them. One attorney mentions a defendant who's supposedly in Dallas and they're trying to get medical records. Another says their client's wife claims he's in the hospital. The judge is going to need proof for every single one of these excuses.
No, it's just like me and my dad, like sometimes we bump heads and a lot with me and.
But you know, a lot of people bump heads, but they don't have criminal charges resulting from that.
And
So are your children placed with you or are they placed with him?
and I live with him.
All right, and you live with him?
Yes.
Is that a part of some type of order that you have to live with him with your children?
Yes.
All right, is that Child Protective Services?
It's business. Business.
Okay.
And Your Honor, I do show that CPS was involved. I do not know the status of that, but he's got CPS records, but just in my experience.
Has that been concluded?
Yeah, they did reinstate it already.
So since February 15th, 2026, y'all telling me that CPS investigated and they're done?
Yes, ma'am. We do, but it's.
Does somebody want to check with CPS? Because you all are saying no harmful or injurious contact. CPS may say there's not to be any contact. I don't know. Does anybody want
When's the
to?
last time you dealt with CPS and
It was when it.
the last case? 2 years ago?
Yes. That's well, we have to contact my dad because I'm obviously.
All right, so let's do this. If somebody can pick up the phone, call the prosecutors who are in room 306 and ask them to look her up. The only thing they'll need her name or either her eldest child's name, and then they can tell us what their orders are. And then their orders can mirror what I'm gonna do here.
Okay.
Because I
You
don't want to
agree with
set,
that?
yeah, because I don't want to set her up for failure. And counsel, I know you need to be somewhere at 11. So we're gonna hold her here. They're gonna call and whatever they say over there, that's what it's gonna say here. If they have no contact there, then I'm gonna enter no contact, okay?
Yeah.
All right, thank you, counsel.
Thank you very much, Your Honor.
Yes.
Preparing to, Lisa.
Thank you.
Now we're getting into the details of Galaxy Guerrero Alvarez's amended conditions. And this is where it gets really important. The state is asking for the BIP course, that's the Batterers Intervention and Prevention Program, which is standard in family violence cases. They're also asking for a UA hotline for 60 days with weekly testing. But the judge asks the critical question, why is there a request for UA hotline? It turns out there was a positive marijuana test back in December, and the new case involved an allegation of alcohol use. So now we have a family violence defendant with substance use issues and children involved. The judge is being meticulous here because she knows that every condition she imposes has to be realistic. Pile on too much and the defendant fails. Don't impose enough and the underlying issues go unaddressed. It's a balancing act, and this judge is very good at it.
You'll be released if once get made. Thank you, Judge. May I be excused?
Yes, you may be excused. Have a good one.
Oh, okay. This is that.
Yes, sir.
You're the law. Excuse me.
Aiden, able to have a card?
Left pages. To the top of left. Judge Brooks.
Yes.
All right, we're in another one of those wonderful courtroom moments where the judge is just being a regular human being. She and the attorney are talking about yard work. He's complaining about it. She says she ripped out all her grass. He thought she replaced it with xeriscaping. And she says she's still designing. She planted fruit trees and told her neighbors to take as much fruit as they want when they grow. I love this because it shows the camaraderie between judges and the attorneys who appear before them regularly. These people see each other day after day, year after year. They develop genuine relationships. And Derek Carpio's actual legal case? His attorney explains there's an unindicted felony charge without lab results or discovery. They need more time, and the judge resets it to June 1st. Business as usual in between the fruit tree conversations.
Page 6 on top, Miss Ruby Luis, states asking for the file, and I'm asking for my client to show up. She hasn't quite appeared yet. Just checking in.
Okay.
I'm running to the 227.
All righty.
Jail days credit. Good morning. I was been hiding out here. Can you text me?
Oh.
Yard. So flower. The other cookies you have in the yard. Talk to factory right now. That's the one I bought. Like my toes, my arm, I'm shaking, one drop of salt. Probably because it's, I can tell drink my and it's weird because I actually used to like the sensation after I got over it. It makes them taste like toes cream. They curve it too far. One, either the big toe and the side, or little toe.
Now, no. No, I don't. I don't. I'm gonna repeat what they were doing. Okay. I forgot all about it.
That's whenever you're ready.
Okay.
Page 3, 1 down.
Yeah.
Derek Carpio. Good morning. How's it going?
I'm doing okay, Jack.
Yeah.
I was complaining about doing yard work yesterday. I'm completely beat down right now.
Well, you know what? I decided I removed all of my grass.
So did I. It was called drought.
Yeah. Well, and it broke my heart, but I said,
Yeah.
no, I want life to be simple.
What'd you do with it?
Oh, I just got rid of it. So, I had been out of my house for over a year. So I had the grass taken up and then it came right back. And I'm like, as much as I've worked this
I
land.
thought you may have like replaced it with xeriscaping of some sort.
Oh, well, I'm still designing. So I have to tell my neighbor.
Yeah.
I'm like, I'm still designing. So it's going to be taken care of this spring.
I'll hopefully get some rain this week.
Oh, gosh, yeah. But I decided to plant some fruit trees. So I told my neighbors, once they grow, come by and take as much
Yeah.
fruit as you want. All right. On this case, I see he has some cases that are not indicted.
That is correct.
And I think, and you're on those as well?
I am. So there's one case that it's a felony charge
Mm-hmm.
and we don't have any labs. We don't have any real discovery on it. And so I've talked to the state. I don't believe they have any as well.
Okay.
So it's kind of a case that they would like to resolve both that and this case together. That other case is, I think, a larger or a higher degree felony.
All right. So you're all going to have to confer off docket. Norma, give me a date in June for this, please. And that will be your plea deadline date. June 1st. Are you available?
I am.
All right. We'll see you back on June 1st. Once you sign the reset form, you'll be excused.
Thank you, Judge, so much.
Thank you. All right, who's next?
I have these 2 pleas available, Judge, but the attorney stepped out of the moment.
That's fine.
Uh-oh.
We were doing the now we start Christmas place too. Minus low.
Jellyfish.
Yeah. Well, I got some that I like because the colors are like too cool. And I like the warm color. So the LEDs are a little too cool. I need to get on your list to get resets. Please.
We could go like.
So they actually have LED glass bulbs. Give off a warm color and then the ones on top. Don't call me yet. I want to talk to this. I gotta tell this other person. Do not Taylor. Yeah.
And then he's missing Bob's signature.
Great news for Galaxy Guerrero Alvarez. The prosecutor was able to reach the CPS investigator and the report is positive. There are no concerns and CPS is in the process of closing the case. That means there will be no CPS mandated no contact order, which simplifies things significantly for the judge's ruling. Now the judge can proceed with amending Galaxy's probation conditions without worrying about conflicting orders from family court. This is what happens when a judge takes the extra step to verify information instead of just assuming. If she had imposed a no contact order that CPS didn't require, it could have separated Galaxy from her children's living situation. If she hadn't imposed one when CPS required it, she could have put children at risk. By making that phone call, she threaded the needle perfectly.
You wait.
Anyone else ready?
I'm waiting for Mr. Leal to come back in, just that's the only one I have.
Norma, can you call Raphael Leo? Oh, I can't see. Hi.
How are you?
Oh, I'm doing great.
I went to court today,
Okay.
so I just wanted to pop in to say, keep looking good, girl.
All right. Thank you.
And yesterday was my birthday.
Oh, happy birth month.
Thank you. Have a good one. You all have a good day. Thank you. Bye-bye. Judge.
Stop.
Oh, Judge, I can see I indicated that Mr. Leal missed a page and I said the attorney was on it.
Mhm.
I didn't even bring it back in.
All right, Norma, you're calling Leo?
Yeah, I'm calling from Judge, I sent him a text and I'm calling him. Going straight to voicemail.
Sir, thank you.
Yes.
Ready now.
I'm gonna find the page.
Your Honor, I was able to get a hold of the investigator in charge of the case for
Mhm.
Galaxy. She said there's no concerns. They are in the process of closing the case.
Yeah.
And so she is not gonna put a no contact order.
Okay.
Thank
All
you,
right,
Judge.
thank you.
Judge, I'm ready with phone.
Just one moment.
Yeah.
All right, Miss Abrams. Miss Alvarez, if you'll come forward, please. All right, so this is what I am going to do. Miss Abrams, if we could do a updated TAP evaluation. They want you to do the BIPP course.
Okay.
All right.
Just sign.
It is a family violence course.
Okay, that's fine.
All right. I'm not doing the live panel, either they want the live panel or the BIP. And that's a lot for her to do both when she has children. And you said she's completed the parenting classes?
Yes.
All right, so let me ask you this, what's going on with you and your dad that
It's because we argue about like certain things about me and my kids, like I said, I'm trying to like be as a mother to my kids. So like, it's been going on since, when I was like there now, but me and him, we did say sorry to each other, so sometimes whenever we do have an argument, we just go our separate ways. And he's a maintenance at that apartment, so I barely see him. So it's just like I said, I don't know, we just sometimes we have like different boundaries, you can say.
Well, here's the thing. Number one, children, they don't need to see that, and they've already had upheaval in their life because you had a CPS case with them, right? So children learn how to resolve issues by watching what other people do. And believe it or not, every time their voice is raised, every time police are called, that creates instability for your children.
Yes.
So you all are going to have to find a better way to communicate. And anytime you get ready to raise your voice or you get angry, you need to think about what your children are seeing. You understand? So, and they told me you completed parenting classes, so you should know this. So do you need a refresher on your parenting?
No, ma'am, no. I just like made it clear with my dad that like we need us to agree in front of the children and we need just go our separate ways, and not argue in front of them. So it's a bad choice, yes. And I don't want my kids to even see that, because they're little. And
Yeah.
I understand that completely.
And here's the other thing that you need to realize. In Child Protective Services cases, what ends up happening when grandparents, the children are placed with them, they become their parents. All right. And so they're still in that mode and you got to respect that.
Yes.
Okay. All right. Good luck to you. You're welcome. Thank you. All right, Norma, on Angel Farias. I don't know why it's not on the system, but it shows here the attorney representing her is Sandhindrick. Deborah Sandhindrick.
This is genuinely powerful. The judge asks Galaxy what's going on with her and her father, and Galaxy explains that they bump heads. It's been that way since she was young. She says they've apologized to each other and they try to avoid each other, but the judge cuts right to the heart of it. She tells Galaxy that children learn how to resolve issues by watching what other people do. Every time voices are raised, every time police are called, it creates instability for the children. And then she asks a pointed question. Do you need a refresher on your parenting? That's the judge holding Galaxy accountable without being cruel about it. And the judge adds something really insightful about CPS cases. When grandparents have children placed with them, they become the parents. They're still in that mode, and Galaxy needs to respect that dynamic. It's family counseling from the bench, and honestly, Galaxy probably needed to hear every word of it. Do you think the judge was too harsh or just right? Let me know in the comments.
And Deborah Sandhindrick came in here yesterday that she was going to have to be in another county, and I think she's up for trial. So recall this and recall it for next week. What date? Monday? And call a jury up here for 11:30. Excuse me. Hi. Hey, on this case involving Eric Cantu, the court reporter took some exhibits. So they should be in the back. Norma,
Yes, sir.
can you show her where the exhibits are for this case?
Yes, it's there. I think that was one of the functions to the cases. Judgment.
Okay. Charles Buck,
Yes.
hi, you wanted to approach on other cases?
I know we're in the middle of serious legal proceedings, but can we appreciate this moment? A defendant walks up and the judge immediately compliments their Gremlins backpack. She asks what cartoon it's from, they explain it's from the Gremlins, the ones you don't feed after midnight, and the judge responds, there were just too many rules for the Gremlin. They were cute until they weren't. First of all, that's a great Gremlins take. Second of all, this is what makes this judge extraordinary. She's making human connections with every single person who walks up to that bench. For a defendant who's probably nervous and stressed about their court case, having the judge notice your backpack and make a joke about Gremlins probably does a world of good for your anxiety level. It doesn't change the legal outcome, but it makes the process feel a little less dehumanizing. That matters more than people realize.
Cases that are both new on your, relatively new to us.
Okay, which one?
First one, let's do Mr. Taylor first, the one you appointed.
Okay, Taylor. All right, Mr. Taylor, if you'll come forward. Hello, Mr. Taylor. All right, how old are you?
I'm 19.
19, okay. All right, your case is going to be reset. This is Mr. Bonk. Make sure that you stay in contact with him, okay? All right, so how much time do you want?
Maybe 30 days. I
Okay,
just want to revisit and buy some cameras with my client, then we'll be ready to
okay,
move on.
let me see here. I can put you at the end of April if you would like.
Okay,
You just tell me
that's fine.
what date.
Okay.
And Mr. Taylor, no more face tattoos, okay?
How about Wednesday, April 29th? I'll already be.
Not on a Wednesday, I can do,
How about Monday, the 27th?
okay? We'll come back on Monday, the 27th. And we'll see where we are. All right. Just have a seat and they'll bring a resign.
Free to leave, okay?
All right, and who else do you have?
Wes with 2 S's, Ruiz.
Let me find him on him. All right, thank you.
Here's that.
All right, Wes Ruiz.
I'd like to come back on that same date for the same discovery.
So we'll have you back on the 27th. Hi.
Hello. Yeah.
Hi, how's it going? I like your backpack.
Thank you.
What cartoon is that from?
It's like the gremlins that don't feed after midnight.
Oh, yeah. Okay, there were just too many rules for the gremlin.
Yeah, they were cute until they weren't.
Yeah. All right, so we're gonna bring you back on the 27th. Do you have any questions about anything?
I guess I.
Yeah, we'll sign.
All right, so just have a seat and once you sign the reset form, you'll be excused.
Okay.
All right, thank you.
Thank you, Judge.
You're welcome.
That motion set aside. Yeah. You heard? Yeah, after December. Can you keep it?
I do. Thank you.
Anyone else ready?
Are you ready again for anything?
No, I'm just gonna wait for nobody
I
to recess.
understand. I have two signing in right now,
Okay.
and Mr. Leal's not in yet.
So sorry, you got it.
My client's on Zoom. He's not on the screen. Why'd you keep waiting? Okay, okay, perfect.
Yes, ma'am.
Okay. Thanks so much.
Going on.
Alrighty.
So you do Ruiz, and I'll do I'll do Taylor, because I know Taylor's case number. I don't know Ruiz.
All right, who's next?
I have Christopher Vermont. I believe they said that he's getting on Zoom right now.
No, he's been on Zoom.
He's been, okay, well, they're ready to approach on him.
All right, Christopher Vurum.
Morning, Your Honor.
Morning. All right. All right, so where are you all on discovery?
So Judge, if we could do one more discovery setting, I think we can be caught up at that point. I do need to review the forensic interview in this case.
All right.
Otherwise, I think we've received everything.
That's correct, Your Honor. And our end, there are several children involved in this case, and defense is house issues that she promised to do. So we
All
have
right,
some time.
Ms. Ferguson, I need 30 days.
Yep.
And state at that time an offer will be due. All right, thank you.
Thank you, Judge.
All right, April 30th. And
Understood, Judge.
your client can appear by Zoom.
Thank you, Judge.
That's a significant question.
Is it always the same? Okay. There's no. Password?
All right, thank you. You're excused.
Thank you, Your Honor.
So did you see a shepherd in your waiting room?
Yes.
Well, the attorney asked the attorney that shepherd had a permission. He said yes.
All right, what page is he on?
Shepherd, man, he's supposed to be back. Confirming. Yes, ma'am, page 7, 1, 2, 3 down.
Yes. All right, are you already on Shepherd?
Good morning. Mr. Barton.
Where's the attorney?
He said that he was gonna be on Zoom as well too. He already took the number and he already took the code.
All right, he's not on. Anyone else ready?
No, ma'am, I do not have anybody else ready.
Hi, were you able to get the exhibits? May I see those, please? Thank you.
Now here's a case that the judge handles carefully, and for good reason. Christopher Veron's case involves forensic interviews, and the prosecutor mentions that several children are involved. When you hear forensic interview and children in the same sentence, you know this is a serious case. The defense attorney needs 30 more days to review the forensic interview, and the judge grants the reset to April 30th. She also allows the defendant to continue appearing by Zoom, which suggests he may be out of the area. Notice how the judge doesn't go into detail about the charges in open court. That's deliberate. Cases involving children are handled with extra sensitivity to protect the victims' identities and privacy. The judge keeps it brief, professional, and moves forward. Sometimes the most important judicial decisions are the ones that happen in what the judge doesn't say.
Just let her know that. Oh, yeah.
Just give me a moment.
Thank you.
Who is it for them? Oh, no.
All right, yes.
Rodolfo Palma, I think he's on page 4 for them. But he did not appear.
All right, could I have a prosecutor, please?
Yes, sir.
Court is calling 2026 CR 01528 State versus Rodolfo Palma Jr. Could I have parties announced?
Rochelle Savella for Mr. Palma.
All right, this hearing was scheduled at 9 a.m. It is now 10:50 a.m. The defendant did not answer docket. Defense, have you added in contact with your client?
Judge, not recently.
Deputy, did you make an announcement for the defendant?
Yes, Your Honor, I did. He is now out there.
State?
We're requesting a bond forfeiture.
And here comes the first arrest warrant of the day. Rudolph Palma Jr. was scheduled for a 9 a.m. hearing. It is now 10:50 a.m. He didn't answer the docket, his attorney hasn't had recent contact with him, and the deputy confirmed he's not in the building. The state requests a bond forfeiture, and the judge goes further. She issues a judge's warrant and remands him without bond. That means when he's picked up, he can't just bail out. He sits in jail until the judge decides otherwise. This is what happens when you don't show up to court. The judge gave everyone fair warning at the beginning of the session. She called names, she made announcements, she waited nearly 2 hours. At some point, patience runs out and accountability kicks in. Rudolph Palma is learning that lesson the hard way today.
All right, the court will issue a judge's warrant remanding your client without bond.
Thank you, Judge.
You're welcome. Anyone else ready? Is that a motion to revoke? All right, here, who's here on Alex Musek?
I am judge.
All right. And where's Alex Musek? All right, and this is a motion to revoke?
Yes.
Are you all ready to proceed on the motion?
No, ma'am.
What's happening?
We don't have an agreement, Your Honor.
No, I mean, is this going to be contested?
Well, it certainly could be. I bonded Alex out about a week ago, or maybe less than 2 weeks ago. Just today, there is a new number 1 alleged. The allegation is not in Bexar County. And just today, I received a police report regarding the incident. I suspect there's probably more discovery out there that the state's not yet in possession of. I would ask the court for just another normal reset so I can obtain information and discovery. And I think the state also needs it as well before we march down the path of the possibility of, I just don't have enough.
Again, I don't know why people file motions and they don't have discovery. Norma, set this in 14 days for a contested hearing. All right, and then if they don't have it, they don't have it.
Thank you, Judge.
You're welcome. You're welcome. All right, who's next?
I was still waiting for the attorney to zoom in for Andrew Shepherd, Martin Guerra. Guerrera. He's still not on?
All right, what page is Shepherd on?
Shepherd is on page 7. I believe so.
All right, Martin Guerra.
Martin Garrett is the defense attorney and Andrew Shepherd is the.
And I believe he filed a motion to dismiss for want of a speedy trial.
Good morning, Your Honor.
Morning. Did you file the motion?
Yes, Your Honor.
All right, could I have the motion? Thank you. And your client needs to appear. All righty. State, are you ready to proceed?
It is ready, Judge.
Court is calling 2023 CR 10058 State versus Andrew Shepherd. Could I have parties announced for the record for the state? Defense?
This case is a great example of why the criminal justice system moves as slowly as it does. Alex Mosk's probation has been revoked, or at least there's a motion to revoke, but the defense attorney explains that there's a new allegation that isn't even in Bexar County, and he just received the police report today. He doesn't have full discovery. The state probably doesn't have full discovery either. So the defense is asking for a normal reset to gather information before they decide whether to contest the hearing. And the judge, who just 5 minutes ago expressed frustration about people filing motions without having discovery, is once again annoyed. She sets a contested hearing in just 14 days, which is a tight timeline. Her message is clear: get your evidence together or don't file the motion in the first place. This is the judge demanding efficiency from both sides.
For the
Do I need
defense,
to say my name or something? Or?
your defense attorney appears to be frozen. All righty. Did you tell Mr. Guerra to zoom back in? And state, do you have any reason for why?
Unstable internet. So.
All right, for the defense.
Martin Guerra, attorney for Andrew Shepherd.
And are you Andrew Shepherd?
Yes.
Any objection to the defendant appearing by Zoom?
Not at all, Judge.
All right, state, the defense has filed this motion stating that his client has been denied the right to a speedy trial. The offense date on this is November 23rd, 2020. And the defendant was not indicted until October 31st, 2023.
And the state has no idea or was not able to discern why there was such a delay in indicting the defendant.
All righty. Anything you want to put on the record, counsel?
Your Honor, if I could ask my client a few questions just related to the prejudice he has suffered and the harm he suffered.
All right, could you raise your right hand, Mr. Shepherd? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I swear.
All right, you can lower your hand, state your name for the record.
Andrew Shepherd.
All right, this is the big one. Andrew Shepherd's defense attorney, Martin Garrett, has filed a motion to dismiss based on the right to a speedy trial. This is a constitutional right under the Sixth Amendment, and the legal standard comes from the Supreme Court case Barker versus Wingo, which established 4 factors courts must weigh: the length of the delay, the reason for the delay, whether the defendant asserted their right to a speedy trial, and whether the defendant was prejudiced by the delay. In Shepherd's case, the offense date is November 23rd, 2020, and he wasn't indicted until October 31st, 2023, nearly 3 years later. The defense is going to argue that this delay has cost Shepherd real job opportunities and subjected him to years of uncertainty. The state is going to argue that the case was sealed and Shepherd wasn't even aware of the charges. This is about to be a real legal battle. Let's break it down.
All right, you may proceed.
Andrew, I know this case took place a long time ago, but since then, has this case affected your employment opportunities?
Yes.
And can you explain that to the judge?
It had affected my employment opportunities. There was 3 specific ones that I can remember off the top of my head that were like in my career field that I've been studying, and they all sent me the offer and then rescinded it, finding out about this pending case that we're here for.
All right, just one moment. All right, thank you. All right.
Andrew, those jobs, they were full-time positions?
Yes, they were.
And how much, well, what was the salary going to be on those? How much would you earn?
Between the three of them, they were between $20 and $26 an hour.
And it was a direct result of this pending case that denied you the opportunity to get those jobs?
Yes.
Now, okay, actually pass the witness, that's all.
Sir, can you hear me okay?
Can you raise my hand again?
Now, are you able to hear?
Oh, barely.
Okay, can you hear me now?
Yes.
All right. So while the offense occurred in November of 2020, you're aware that you were not formally indicted until October of 2023. Is that correct?
I was unaware.
Okay. So you were unaware that any charges were pending against you until 2023. Is that correct?
Andrew Shepard is now under oath and testifying about the prejudice he suffered from this delay, and it's compelling. He says 3 specific employers offered him full-time positions paying between $20 and $26 an hour, and all 3 rescinded their offers after discovering this pending case. Think about that math for a second. At $23 an hour average, working full-time, that's roughly $48,000 a year. Over the years this case has been pending, we're talking about potentially hundreds of thousands of dollars in lost income, and these weren't just random jobs. They were in his career field that he'd been studying for. The pending charge didn't just affect his wallet, it stalled his entire professional trajectory. This is exactly the kind of prejudice the Barker factors are designed to address. But the question is, will the judge find it sufficient?
I was unaware that any charges were against me until recently, like a few months ago.
Okay. And then you had a court setting that was set on January 5th of 2026 that you failed to appear to. Is that correct?
I thought that was allowed to be like Zoom call. I think so. Correct.
I'm
In
sorry.
short.
Just stop for a moment. The court reporter is unable to hear. I'm unable to hear. So, did you hear the state's last question?
It was about a court hearing in January, correct?
The question was,
Can you hear me?
did you fail to appear to your court setting on January 5th of 2026?
I did because I thought the case had been dismissed at that point.
Okay, why did you think that?
Can we hear me?
Why did you think the case had been
Because I got a message from my lawyer saying that the case had been dismissed by my lawyer, but he had explained to me that there was a Shepherd in his file that he attended for court that same day. So I guess he confused my case with his, and that's why I wasn't present.
Okay. And then you were arrested for this offense in December of 2025. Is that correct?
Yes, I was extradited.
Okay. And that's when you were made aware of the charges pending against you?
Yes.
Okay. We pass the witness, Your Honor.
Thank you.
Andrew, I understand there was some confusion about your court date, correct?
Yes.
But you never received any notice that you were ever indicted by mail, did you?
No.
And had you received any notification, you would have
Now the state gets their turn, and this is where it gets interesting. The prosecutor asks Shepard about his missed court appearance in January 2026. Shepard says he didn't appear because he thought the case had been dismissed. His lawyer apparently confused his case with another Shepard. That's a pretty significant error by the defense attorney if true. The state is trying to paint a picture that the delay isn't entirely the government's fault. If Shepard missed court dates and wasn't actively pursuing his case, that undercuts his speedy trial argument. Then there's the fact that Shepard was arrested and extradited in December 2025. He was brought from Tennessee to Texas to face these charges. The state is asking targeted questions designed to show that Shepard hasn't been significantly prejudiced. He's only spent 2 days in jail, and he still has his witnesses available. But watch how the defense responds.
complied with that notice. Yes?
Of course, of course.
And so even though, again, the prosecutor asked if you were aware that your case had been indicted, but even though you didn't know whether or not it had been indicted, you knew it was still pending.
Yes.
Passway.
Can I ask a few questions?
Sure.
Mr. Shepard, let me ask you, have you lost any witnesses that could help in your defense since you were arrested?
I have my mother, but she's currently unavailable. She's at work right now.
Okay, how would your mother be a witness to the defense, or do you?
I have been living with her since I had moved back to Tennessee back in December of 2023.
Was she there when you were arrested? Oh.
Yes.
Yeah.
Can't understand, like, every word.
All right, this is what we're going to do. Any objections to this witness being by phone?
No, Judge.
All right, so you need to, attorney, if you can call your client.
Oh, me? Are we having trouble hearing me?
Yes. So your attorney's going to
Oh,
call
okay.
you, and we're going to have you by phone.
Okay, I apologize.
No problem.
I just put him on.
Here's where the defense attorney really earns his fee. The state has been arguing that the relevant time period is only from the 2023 indictment to the present, because the case was sealed before that and Shepard didn't know about the charges. But the defense fires back with a critical point. The state had the evidence in their possession since 2020. They chose to file the case at large, meaning they submitted it for grand jury consideration without arresting the defendant first. The defense argues that the entire 5-year period should be considered, not just the post-indictment period. And here's a devastating detail. The indictment came just 1 month before the 3-year statute of limitations would have expired. The state waited until the very last moment. Whether that was due to diligence or negligence, the defense argues it doesn't matter. The delay is presumptively prejudicial under Barker because it exceeds the 8-month threshold by years. This is excellent lawyering on both sides, and the judge has a tough call to make.
Speaker, Your Honor.
Yes.
Andrew, I'm going to put you on speaker. Yes.
My apologies.
All right, if you'll move it towards the court reporter.
May I continue, Judge?
Yes.
Okay, Andrew, can you hear me?
Yes, I can.
Okay. Okay, so you said that you wouldn't be able to call your mother as a witness? Okay, but I'm talking about at trial, man. Would you be able to call your mother as a witness at trial? Okay, so you do have witnesses that you're still able to procure since your arrest? Okay. What about, is there any evidence or anything that could help in your defense that you've lost since your arrest?
He's not a legal expert.
Judge, I
Well,
have to
he's
stop
going
for
through
correct
the
this.
Barker factors, I believe.
Yes, Judge.
Overrule.
Andrew, do you want me to repeat the question? That's okay. So is there anything any evidence like video or material or something like that that could have helped in your defense that you don't have now because of the time?
So that's been so long.
Okay, so you haven't lost any witnesses or any evidence that could have helped in your defense, even though it's been about 6 years since you were arrested? that all right?
I'm sorry, have I lost any evidence due to the time frame?
Okay. And let me ask you, so how many times have you been arrested for this?
First time, 2020, and then when I was extradited. The only time. Release that I had heard of.
Okay, so it wouldn't be a surprise to you if our records show you've only spent 2 days in jail?
State of Texas and Bexar County, that sounds accurate because the first time I was released that same day, and then the day that's when I was extradited.
Okay, so Andrew, let me ask you, I've contacted my witnesses. I'm ready for trial. Do you want a trial on this today or do you want a dismissal? Okay, thank you. We'll pass the witness, Judge.
Defense?
Now, Andrew, do you even know which witnesses might potentially be called against you? Do you know if any of those names of witnesses have been turned over?
No, I'm unaware about any of it.
Okay, and you said you spent 2 days in Bexar County or 2 days in jail. I mean, is 1 day harmful to you? Is 1 day a good thing?
No, it was all terrible.
Pass the witness, sir.
No further questions, Judge.
All right. Is there a reason why there was such a delay in the indictment?
Judge, so that's what I wanted to address, just so the record is clear. So while the defendant was, he was arrested on municipal warrants on November 23rd of 2020 and then released from the Frio facility. This case was turned in at large, so the record was sealed against him until he was indicted in 2023. And so I think, and the analysis, he was unaware that these charges were pending against him between 2020 and 2023. So I think that's a relevant time period that we're looking at for the Barker factors is 2023 to 2020. Judge. Yeah, so since it was sealed, I mean, he was not made aware of it, so I don't believe that it was holding prejudice. And when I just cross-examined him, he said he wasn't made aware of it until he was arrested, so.
Your Honor. With all due respect, that's wrong. The relevant date for the day of the arrest to the time of his court date. Now, he knew when he got out on his PR bond that the case was pending. It's not the job of him to find out whether or not he gets indicted. What happened basically is we have a delay of 5 years.
And what is the date of arrest?
The date of arrest is November 23rd, 2020. And from that date to the date of his first court
I'm
date,
sorry, you say arrest date is what date?
November 23rd, 2020. From the time of that arrest date till the time of his first signed date in court, that was 5 years, 1 month, and 13 days. The state was in possession.
So wait a minute, because they're saying that this was at large.
Judge, so that I would ask you just to take your course in the court's file because this is contained within the court's record. And so what I'm looking at on Odyssey right now is that the record against him did not become unsealed until October 31st of 2023. So no charges were pending against him up until that date when he was indicted by the grand jury on October 31st of 2020.
All right, and so counsel, the arrest you're speaking of, is that the arrest on municipal warrants?
No, Your Honor. That was the arrest date for this offense. November 23rd, 2020. He gets arrested. He gets released on a PR bond. Then his first court date comes.
All right, so let's do this. So when was he released on a PR bond for this case?
I could just have a minute, but when
Yes.
I'm looking in Odyssey, it does not show that he spent days in jail for this offense, but I made a double check.
Okay.
It's still in part of Odyssey.
And when was the extradition done?
That was on this. He arrived in Bexar County Jail on December 3rd, Your Honor, of 2025.
And so per Odyssey, he was booked for this offense on December 3rd of 2025, and per Odyssey had 2 days of confinement. So he was booked on December 3rd of 2025 and released on December 4th of 2025.
All right, so this is what the court wants to know for certain. Because you're saying that he was actually arrested in 2020. The state is saying he was not arrested in 2020. So state, if you can show the defense the documents you have.
So I can show, and this has been tendered to defense, but based on my reading of the offense report, he was taken to Frio for the municipal warrants, but was not, he can't be booked at Frio for that. He had to be taken to the county jail. And so he was released from the Frio facility on those municipal warrants. He was not booked for the offense that was here for.
So there was no double booking.
Not to my knowledge, Judge.
All right, so if you all can just double check that so that the record can be clear and I can be certain.
Yeah, you know, and Your Honor, the other thing too, though, is that, I mean, even if, let's say for the sake of argument, he was booked on municipal warrants, the state is still in possession of evidence like used against my client for this case. That evidence was submitted for testing and in their possession. And I'm talking.
But one of the factors I have to look at is delay. In order for me to consider delay, I need to know the specific dates. So if you all could.
And Judge, I believe that's a mischaracterization, because when cases are filed at large, it's because the police department is doing due diligence and receiving the lab reports before it's ever sent to the DA's office.
Yes.
So that's the purpose of the record keeping seal.
Okay. All right. So we'll go off the record to the court reporter so they can look through that. And so if you all will step back and review that, and I'll take up Mr. Leal's case.
This is where the legal argument gets really nuanced, and I want to make sure everyone understands what's happening. The state says the case was filed at large, and the record was sealed until the indictment in October 2023. That means there was no public record of the charges against Shepard. The defense attorney, however, points out that his client recalls being arrested for these charges back in 2020 and released on a personal recognizance bond. The state says that arrest was for municipal warrants at the Frio facility, not for this felony offense. This is a critical factual dispute because it determines when the speedy trial clock starts ticking. If Shepard was arrested and bonded out on this charge in 2020, the delay is over 5 years. If the clock only starts at the 2023 indictment, it's about 2 years. The judge does the smart thing. She tells both sides to go verify the exact date so the record is clear. Good judging means getting the facts right before making the call.
All right, Aiden Falcone. And where's your client? Are there any applications in any of this?
Yes. What the fuck?
All right, court is calling 2026 CR 0000515 State versus Aiden Falcone. Can I have parties announced?
Rafael Leal for Mr. Falcone.
And are you Mr. Falcone? Yes. Counsel, in that case, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Falcone, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? I don't have a copy of the indictment, but did you review the indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yeah.
Right, did you review the court admonishments with your attorney? Did you understand it? And
This is where the legal argument gets really nuanced, and I want to make sure everyone understands what's happening. The state says the case was filed at large, and the record was sealed until the indictment in October 2023. That means there was no public record of the charges against Shepard. The defense attorney, however, points out that his client recalls being arrested for these charges back in 2020 and released on a personal recognizance bond. The state says that arrest was for municipal warrants at the Frio facility, not for this felony offense. This is a critical factual dispute because it determines when the speedy trial clock starts ticking. If Shepard was arrested and bonded out on this charge in 2020, the delay is over 5 years. If the clock only starts at the 2023 indictment, it's about 2 years. The judge does the smart thing. She tells both sides to go verify the exact date so the record is clear. Good judging means getting the facts right before making the call.
sign it in all the appropriate places. All right, you're charged with possession of a controlled substance, penalty group 2, 4 to 400 grams. That's a second degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fines. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea, it gives you more than you bargained for. The fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is and he was.
Mr. Falcone, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 5 years in the prison. There's a $1,000 fine to be probated. State recommends deferred adjudication. This is to run concurrent with 2026 CR 003426. It's the court's understanding you've applied for deferred adjudication in community supervision.
Yes, Your
So what does he prefer? Deferred?
No, I mean deferred, I'm sorry. Yeah.
Judge, I believe that, my apologies, that was probably a typo. I
Okay.
believe that it was gonna be a probation offer, but we are going with a offer for adjudication.
Okay. All right, then, did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
It is, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 5 years. There be 100 hours of community service restitution. No contact with Idrick, AYDRICK, Compeon, COMPEON, the DOEP course, MRT, and prohibited possession of firearms and ammunition.
If I can interrupt, I think it's Compion with an A, PEA.
Oh, okay.
It's my apologies, Judge.
You all need to start printing.
Yes, ma'am.
So it's COMPEAN.
That's correct, Judge.
All right. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations? Then to the offense, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Now we're moving into one of the most thorough plea colloquies of the day, the Aiden Falcone case. For those unfamiliar with the term, a plea colloquy is the formal process where the judge ensures the defendant understands their rights, the charges against them, the potential punishment, and the terms of the plea agreement before accepting a guilty or no contest plea. In Texas, this process is incredibly detailed. The judge goes through every single right the defendant is waiving: right to jury trial, right to cross-examine witnesses, right to remain silent. She explains the range of punishment: 2 to 20 years in prison and up to $10,000 in fines for a second-degree felony felony possession charge. She explains what deferred adjudication means and the consequences if it's revoked. She asks about immigration consequences. This isn't just procedural box checking, it's constitutionally required to ensure the plea is knowing and voluntary. If any of these steps are skipped, the entire plea could be challenged on appeal.
Evidence.
That would be up to say exhibit number one, including all exhibits.
No objection.
All right, did you state you may be excused? Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, there was another case.
We're gonna do this one first.
Okay. The client was, it's only barely 18 and a half years, and he was around 17 when this happened. My client has suffered not only on the charges of this case, but also he was shot by, and he's suffering from an arm condition that he cannot operate his arm. There is a case pending against the alleged shooter in the future, but I guess what I'm trying to say, Judge, is that my client has paid dearly already for his.
When were you shot?
August.
I'm sorry?
August 9th.
August 9th of what year?
2025.
I mean, this happened in July. So what are you doing with your life? You need to speak up.
Switch it around.
All right, just 1 second. Everyone needs to whisper, and I'm sorry, you need to speak up.
Just going the right path. I got a second chance at life. I got shot in the face.
Mhm. So how old are you?
I'm 18.
Are you in school?
Yes.
Where? What do you do?
Restore education.
I'm sorry, what?
Restore education. I'm about to get my GED, and I work with my dad, basically full time.
Okay, do you have any children?
No much.
You're not ready. All right, this is what the court is going to do. 3 years deferred adjudication, regular UAs. If you're drug tested today, what the results will be? All right, there's to be regular UAs, $1,000 fine probated. This run concurrent with 2026 CR 003426. There's to be no possession of firearms or ammunition. There's going to be a 100 hours community service restitution. You'd obtain your GED. Once you've obtained your GED, the community service hours will be deemed satisfied. There's going to be field visits 1 time per month for 6 months. I'm sorry, 1 time per month until further notice. There's to be proof of employment within 60 days or SSI within 60 days. No employment as a home healthcare provider or with minors. TAP evaluation out of custody. Follow TAP recommendations. There's to be no contact with Idric Compion. Probation, is there anything else with regards to that case? All right, did you review the document in that case called Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, who's the prosecutor on the family violence case?
There's no family violence.
Okay, thank you, Meg.
Now we hear the human story behind the legal proceedings, and it's heartbreaking. Aiden Falconey's defense attorney explains that his client was barely 18, around 17 when this offense occurred. But here's what makes this case so tragic. Aiden was shot. He has a permanent arm condition. He cannot fully operate his arm. There's apparently a pending case against the person who shot him. His attorney argues that Aiden has already paid dearly for his choices. And when the judge asks Aiden directly what he's doing with his life, his answer is telling. He says he's going the right path and that he got a second chance at life after being shot. He's 18 years old, working on his GED, and he has no children. The judge fashions a sentence of 3 years deferred adjudication, reduced from the proposed 5 years, with community service hours that get waived once he completes his GED. That's the judge investing in his future, not just punishing his past. At 18, with the right support, this young man could turn everything around. But the streets have a way of pulling people back. Will he make it? I genuinely hope so.
Court is calling 2026 CR 001210 State versus Amador Garza. Can I have parties announced?
Ready for the state? Ray Lopez for the defense?
And are you Mr. Garza? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Garza, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right, Mr. Garza, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes,
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? All right. Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 2 years in the prison, in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Garza, has anyone threatened you, coerced you, or placed you in fear to get you to enter plea?
No, Your Honor.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Okay, you need to speak up.
Yes, Your Honor.
Court will find the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, I did.
According to the plea, punishment is to be assessed at $1,000 fine probated, and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
It is, Your Honor.
State?
It is, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, I did.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be 100 hours of community service restitution, the DOEP course, and MRT. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Judge, you offer exhibit number 1, including all of its attachments.
Any objections?
No, Your Honor.
All right, did you review the waiver and state you may be excused?
Thank you.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
All right, off the record. Deputy, could you have them move to the other end? They're talking behind the court reporter. All right, we're back on the record. Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulations of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just to ask the court to follow the deferred adjudication agreement if he wants a chance to keep this off of his record.
All right, are you employed?
Yes,
What do you do?
I'm a truck driver.
Okay.
CDL driver.
And do you travel throughout Texas or to different states?
Just local.
Okay. All right, this is what the court is going to do. 2 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs or the patch, $1,000 fine, probated, field visits 1 time per month for 6 months, proof of employment within 45 days, no employment as a home health care provider or with minors. Defendant is allowed to travel throughout Texas for employment. If it changes and they have you going out of state, you'll need to let probation know. TAP evaluation out of custody. Follow results. And I'm going to ask for 30 sober support meetings in 30 days. Probation, is there anything else?
No, Judge.
Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. All right, good luck to you. Probation will go over conditions. Norma, on this one, you have no name on this. All right, on Taurus. Yeah, but what's the name? What's the person's name? All right, who's here on Taveros?
Submitted it to this.
All right, is he here?
I believe he was in the misdemeanor court, so.
Okay,
He's been around, I saw him today.
all right, thank you. You're welcome. Just give me one moment. Let me do this real quick. All right, this needs to go to County Court 12.
Yes, ma'am.
All right, on this case, the prosecutors need to sign it. Who is here on Aiden Falcone?
Mr. Rios is here.
Thank you.
Thank you, Judge.
No problem.
What's that for me?
Thing one witness. Which one did your family violence? It matters. Hmm?
He just played that.
Yeah, he just played.
All right, the party's on Shepherd.
Thank you, Judge.
Yarn, do you want me to get him on the phone again?
Yes. Okay.
Andrew, I'm gonna put you on speaker.
Okay, so just a moment. Just give me 2 seconds.
No.
All right, we're back on the record in 2023 CR 10058, State versus Andrew Shepherd. Could I have parties re-announce?
Brendan Frater and Megan Galloway for the state.
Martin Garrett, attorney for Andrew Shepherd.
All right, and Mr. Shepherd, you're by phone, is that correct?
Yes,
All right, so there was some slight confusion on the record. And so I want the record to be clear with all of the dates. Have both state and defense had a chance to confer on dates?
Yes, Your Honor.
All right, so if you all can give me the dates.
Yes, so according to the official record, the case was indicted on October 31st, 2023, and the record was unsealed on October 31st, 2023. The post indictment fugitive warrant went out on October 31st of 2023. And regarding days that the defendant was in custody regarding this case, there's only one booking, and that is built in the Bexar County Jail on December 3rd of 2025 and released on December 4th of 2020.
All right, in defense, do you agree with those dates?
Your Honor, I agree that that's what Odyssey says. My client was clearly under the impression that he was arrested for these charges back in February or November 23rd, 2020. Moreover, I would say that at least the Bexar County Attorney's Office, it seems that they had treated the critical date as November 23rd, 2020, because this is a felony drug charge with a statute of limitations of 3 years. And I think it's important to note that he was indicted 2 years and 11 months from that date that my client said he was arrested on November 23rd, 2020. Again, I know that I've had problems with some of the accuracy of Odyssey, and I'm not the only person in the county that's had problems with some of the accuracy of Odyssey. So I agree that's what Odyssey states. But in terms of was my client arrested or not, my client, his recollection is that he was arrested for this charge on that date, November 23rd, 2020. Even then, just simply going by the date of his indictment, that's still more than 2 years, and that's well in excess of the 8-month trigger for the presumption of prejudice.
Okay. All right. Any,
I just would respond, I think those are two separate issues, right? The state is under a legal obligation to indict after the date of the offense, however, not on the until December 2025. And so I just want to re-urge my argument of the record regarding this case was sealed against the defendant regarding the way that it should be from 2023 until present.
all right, the motion to dismiss will be denied. If your client wants a speedy trial, if he's here by tomorrow, we can try tomorrow. Or, so do you want to discuss when your client wished to have this case tried? And I don't know if the state would have objections to your client appearing by Zoom for trial or not, but that would include a lot of waivers that would need to be done in writing. So.
Well, I'll talk to the state, talk to my client.
Mhm.
But I request some findings of fact before you line on.
Sure.
Thank you.
All right, thank you. All right. All right, Kimberly Tarwater. If you come forward. Hi, your attorney is currently in trial in another county. And also, your attorney has a vacation letter on file. And many times we don't receive that. And even if it's set, even if they file a motion for speedy trial, we don't necessarily see it unless they filed with it a motion for continuance. So Norma, set this for May 14th. All right, so once you sign the reset form, you excuse. Mhm. Oh, thank you. Deputy Laura, tell the jurors to be back here by 1:45. Anyone else ready?
Yes, ma'am, I have that there. Yes, A2
Everett Ennis. Who's the attorney for Maverick Ennis?
Here, Judge.
And where's Mr. Ennis?
You know, we reached out to him, Your Honor, and his wife said he was in the hospital. We haven't been provided any documentation or anything.
Just one moment. Deputy Laura, if you can make an announcement. Court is calling 2025 CR 002-989 State versus Maverick Ennis. Can I have parties announced?
Megan Galloway for the state.
And George Manning for the defense, Your Honor.
All right, this hearing is scheduled at 9 a.m. The defendant has not answered the docket. Counsel, have you had any contact with your client?
I haven't, Your Honor. We reached out and his spouse said he was in the hospital. We said we needed documentation and we haven't received it yet.
All right, Deputy Laura, did you make an announcement? State.
We're requesting a bond.
All right, the court will issue a judge's warrant, remand your client without bond. If he presents documentation in the day, the court will reconsider.
Thank you, Your Honor. May I be excused?
Yes.
Have a good day.
Who's ready?
Judge, I'd like to talk to Miss Louise, the one I did earlier, Ruby Louise.
I'm sorry, who is it?
Ruby Louise, page 6.
And there's the ruling. The motion to dismiss is denied. The judge has weighed the Barker factors and determined that the delay, while lengthy, does not warrant dismissal. But here's the key part that a lot of people might miss. The judge immediately offers Shepard a speedy trial. She says if he can be there by tomorrow, they can try the case tomorrow. That's significant because it addresses one of the Barker factors directly, the defendant's assertion of his right to a speedy trial. By offering an immediate trial, the judge is essentially saying, I've acknowledged the delay, I've denied your dismissal motion, but I'm giving you the fastest possible path to resolution. The defense attorney says he'll discuss it with his client. If Shepard really wants this over, he could be in trial within days. But does he actually want that? Or was the motion a strategic play to get the case thrown out? That's the real question. What do you think his next move should be? Drop it in the comments.
Yes.
She no showed this morning and I'm just gonna head up to Comal County.
All right, court is calling 2026 CR 002-096 State versus Ruby Louise. Could I have parties announced?
Megan Galloway for the state.
Glenn Payne for the defense.
All right, this hearing was scheduled at 9 a.m. It is now 11:52 a.m. Defense, have you had any contact with your client?
Not personally, Your Honor. A boyfriend called, said she was on the bus this morning and we've had no other contact.
All right, state.
We're requesting a bond forfeiture.
Deputy Laura, did you make an announcement?
Yes, Your Honor, she's not out there.
All right, the court will issue a judge's warrant, remand your client without bond.
Thank
Thank
you, Judge.
you.
Maybe excused.
Anyone else ready?
Yes, ma'am. They're the same.
Who is here on Amadean Smith? Where's Amadean Smith?
He's in the box, Your Honor.
All right, are you all proceeding on the motions?
Yes, sir.
Yes, Your Honor.
All right, the court is calling 2024 CR 3014W and 2023 CR 8440 State versus Amadean Smith. Can I have parties announced for the record?
Attorney Bill Simmons for defense.
And are you Mr. Smith?
Yes, ma'am.
And each cause numbers, did you review the motion to revoke community supervision and first amended motion to revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Amadean Smith who was placed on community supervision in 2024 CR 3014W for the offense of harassment of a public servant on March 4th, 2024 for a term of 8 years?
Yes, ma'am.
And are you the same Ahmed Bayam Smith who was placed on community supervision in 2023 CR 8440 for the offense of harassment of a public servant on March 4th, 2024 for a term of 8 years? Is that you?
Yes, ma'am.
State, are you proceeding on the same allegations in each motion?
Yes, Your Honor, and that's violation of condition number 40. On or about the first day of August 2025 in Bexar County, Texas, the defendant, Amadean Jordan Smith, did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department's fully diagnosed residential facility, and that the defendant was successfully discharged from the program in violation of condition number 40.
How do you plead to that? True or not true?
True.
All right, off the record for a moment. I don't have that as a allegation in cause number ending in 40. I have it in 14W. Do y'all have it in 40? Ah, okay. All right, thank you. We're back on the record. All right, did you understand by pleading true to violation of condition number 40, the court could find it true, grant the motion, and sentence you up to 10 years in the prison?
So,
Knowing that, do you still wish to plead true to violation of condition number 40? In each cause number, the court will find violation of condition number 40 true. Is there a proposed agreement?
There is, Your Honor, it is to grant the state's motion, revoke the defendant's community supervision, and reform the judgment to reflect a 5-year sentence in prison. In each cause number.
Okay. Is that the agreement?
yes, Your Honor. So with him receiving all time for all the time that he has already.
The judge is now cleaning house on defendants who didn't appear, and the consequences are real. First, Maverick Innes. His attorney says his wife called and said he was in the hospital, but there's no documentation to back it up. The judge issues a warrant, no bond, but she leaves the door open. If he provides documentation today, she'll reconsider. That's fair. Then Ruby Louise. Her hearing was at 9 a.m. and it's now 11:52. The defense attorney says a boyfriend called to say she was on the bus this morning, but there's been no other contact. Another warrant, no bond. Here's the lesson, and I cannot stress this enough. If you have a court date, you need to be there, period. If you're in the hospital, have someone send documentation immediately. If you're running late, call your attorney. Silence and absence are interpreted as contempt for the court, and the judge's response, warrants without bond, ensures that when these defendants are eventually found, they won't be able to just bail out and disappear again. The system has checks and consequences, and today, those consequences are being enforced.
Are you asking me to follow this agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right. So you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. So why were you not successful with the program?
People were mean to me.
I'm sorry, what?
People were mean to me. Some of the people at the program.
What did he say?
People were mean to me.
People were mean to you? How so?
Just mistreating me.
How so?
Calling me names and trying to start fights with me.
And who are these people?
Just some of the people, inmates that were in the program.
Okay. So what's your diagnosis?
Schizophrenia, depression.
All right, Ms. Abrams.
The way that it happened was he basically left PPR. He escaped the program. He was there for 3 days and was unsuccessfully discharged. This is his third MTR.
Is he on any type of medications? Does anybody know, is he currently, is he current on his medications?
In my conversation with him, our visit that we had, for the gym, my understanding is that that is in flux, but he has met with the mental health at.
All right, what does that mean that's in flux? Is he on his medications?
So that's my understanding, but they could have been, I always ask whether or not they, even though I'm not a doctor, Your Honor, are the meds working for you? So when I say something like, are they in flux, and he gives me a different answer, that's what I meant. Sorry. You recall that conversation?
All right, once you're released from prison, if I follow this agreement, do you have a place to go?
That's all.
All right, this is what the court is going to do. The court is going to revoke you in each cause number. The court will sentence you to 3 years in the prison, give you credit for any time served. The court will request the therapeutic community. And I'll ask for the mental health unit at the prison. All right, did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Oh, and I'm sorry, these cause numbers will run concurrently. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
That's all.
All right, because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
That's all.
All right, good luck to you.
We have excused, Your Honor.
Yes, thank you. All right, court is going on recess. I'll see y'all back at 1:30.
And just like that, after nearly 3 hours, this Bexar County courtroom is finally going on recess. What an incredible session. Let me walk you through the biggest moments one more time. Rahul Iglesias received what may be his final warning: complete his probation requirements, including drug testing, defensive driving, and either a GED or trade school, or face up to 12 combined years behind bars. The judge made it crystal clear. The next conversation will involve a motion to revoke and a trip to the county jail. Lorenzo Garcia was granted his occupational driver's license after demonstrating full compliance with his felony DWI probation, proof of insurance, a clean driving record, and a properly maintained ignition interlock device. He can now drive to work, probation, church, and handle basic necessities within the hours specified in his order. The judge called out a systemic problem: cases being indicted without complete medical records, questioning why defendants' lives are being disrupted when the evidence may not even support the charges. That's accountability directed upward, not just downward. downward. Galaxy Guerrero Alvarez had her motion to revoke withdrawn and her probation conditions amended. The judge took the extra step of verifying CPS status to make sure the criminal court orders wouldn't conflict with any family court orders, protecting both Galaxy and her children. Andrew Shepard's speedy trial motion was denied after a detailed hearing on the Barker factors. Despite a 5-year delay between offense and court appearance, the judge found insufficient grounds for dismissal, but offered an immediate trial, putting the ball squarely in Shepard's court. Young Aiden Falcone, just 18 years old and bearing permanent gunshot injuries, received 3 years of deferred adjudication for a second-degree felony drug charge. The judge waived his community service hours upon completion of his GED, investing in his education as a path to redemption. Amadar Garza received 2 years of deferred adjudication for drug possession, with conditions including sober support meetings, employment requirements, and regular drug testing. Amadine Smith, struggling with depression and failed treatment programs, had his probation revoked and was sentenced to 3 years in prison, reduced from the proposed 5, with a request for therapeutic community placement and the mental health unit. And multiple defendants who failed to appear, Rudolph Palma, Maverick Innes, and Ruby Louise, had arrest warrants issued without bond. Through it all, the judge displayed a remarkable combination of firmness, compassion, efficiency, and humor. She cracked jokes about Netflix movies and Gremlins backpacks. She welcomed college interns and plugged court reporting as a career. She took photos with the defendant's family. And when it was time to be serious, she was absolutely unflinching, warning defendants about prison, questioning prosecutors about missing evidence, and issuing warrants without hesitation for those who disrespected the court's time. This is what real justice looks like. Not the sanitized version you see on television, but the messy, complicated, deeply human reality of a courtroom where every single person who walks through that door is carrying a story. So let me ask you, which case stuck with you the most today? Was it the teenager getting a second chance? The mother trying to navigate family violence and CPS? The man with depression being sent to prison because the system couldn't stabilize him on the outside? Or was it the 5-year speedy trial battle where a man's career was derailed by a case that sat dormant in the system? Drop your thoughts in the comments below. I read every single one, and I want to hear your perspective. And if you found this courtroom breakdown as gripping and eye-opening as I did, do me a huge favor. Hit that like button right now. Share this video with a friend who loves legal content or true crime breakdowns, and make sure you subscribe to the channel with notifications turned on so you never miss another session. We cover real courtroom cases, real rulings, and real human stories every single week. No scripts, no dramatization, just the raw truth of what happens when people stand before a judge. We'll see you in the next one. Take care, everyone, and remember, show up to your court dates.